Welcome to Lawyer Up with HMC, where we unravel the complexities of legal battles, share insights into high-stakes litigation, and provide strategies for navigating the legal landscape. Join us as we delve into and discuss common legal issues and interview industry professionals and experts in the field. Whether you're a legal professional, a business owner, or simply curious about the world of litigation, our podcast offers valuable knowledge and practical advice to empower you in your legal journey. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Now here's the host of the Lawyer Up with HMC podcast, Kristen Hagg.
Hey everyone, welcome to Lawyer Up with HMC. I'm your host, Kristen Hagg. On today's episode, we will be diving into the world of human resources and discuss some of the more common employment law issues encountered by businesses, and also get into how businesses can optimize their HR practices in order to mitigate risks. And so joining me for the discussion today are two guests. First, from HMC Lawyers, we have Meagan Potier. Meagan joined HMC as an associate in 2019, and over the last 6 years, she has developed a diverse civil litigation practice that includes handling employment law matters and disputes. Prior to law school, Meagan received a BA from McGill University in religious studies with honors. And during her undergraduate degree, she volunteered as a crisis counselor and worked as a research assistant. She continues to be passionate about volunteer work and community involvement. Welcome to the show, Meagan.
Thanks, Kristen. Thanks for having me here today. It's a really fun thing to participate in. I also love listening to people talk about my bio. That's always interesting. You don't think about it very much until you hear somebody repeat it back to you.
I don't know. You're like, maybe I need to update this, but yeah. It's all good. It's all good. And our other guest today is Vered Levant. She is the lead executive officer of VIMY HR. They specialize in no-nonsense HR solutions for Canadian companies. VIMY HR was born out of a desire to provide accessible HR advice and support for all Canadian small businesses. Vered is an advocate for inclusion, economic empowerment, and equity in our communities. She has been a volunteer since her early teens and is currently a board director with the Calgary Immigrant Women's Association and Better Business Bureau, servicing Alberta and East Kootenay. Welcome to the show, Vered.
Thanks so much for having me, Kristen.
Before we get into the topic, I feel like I gave you guys both very mechanical overviews of yourself, and I think it would be helpful for our listeners to hear a little bit more from each of you. And so now this time, Vered, I'll start with you. Maybe tell us a little bit more about your background and the path that brought you to where you are today at VIMY.
Yeah, so prior to starting VIMY, I found that what gave me the most joy was working with leaders and supporting them in achieving their company objectives, elevating their leadership capabilities. And then I found myself, after 15 years working in corporate, working with a small startup, and maybe not doing all of the HR things, but seeing where there was a lot of opportunity to support business strategy, support communications, and really started to see there was a huge opportunity to support their operations and create some real support for them in scaling. And so then I started VIMY HR, and our focus is in particular helping entrepreneurs scale their organizations using practical HR strategies.
Great. Awesome. And Meagan, what about you? Let's hear a little bit more about your background and maybe how it is that you've sort of developed a bit of an employment focus to your practice.
Certainly. So as you said, I've been at HMC since 2019. And when I started at the firm, my background was mostly in criminal law, which is extremely different from what I practice now. But I would say kind of the primary overlap is what I was passionate about in law school was working directly with people and working in situations where I'm helping people sort of achieve a demonstrable goal. They're looking to do something in particular, basically. They're results driven. Employment law, I started mostly doing employee side work because employees, the relationship with your employer is one of the most important ones that people tend to have. So as in criminal law, it felt like I was working really to help people towards a particular goal, to achieve something that was really important to them personally. Now, as I've gone a teeny tiny bit more senior, though I'm still very junior in the grand scheme of lawyers, I've started to work more with businesses and again, mostly small businesses, helping them work towards achieving what it is they want to achieve, which is usually trying to find a way to maximize their business, do what they can to be as successful as possible, which means having good relationships with their employees, which means, as Vered has indicated, mitigating risk, helping them mitigate risk through legal strategies, helping them deal with legal issues as they arise, kind of from an employment perspective.
Great. And you mentioned your seniority. I style my hair strategically so people can't see how much gray hair there is, but I was going to say you have a lot of gray hairs to grow. Yeah, you're still pretty fresh, but no, you've been here for a number of years and moving right along. So
yeah.
Anyways, so getting into the topic of the day. So as litigators, we're most often dealing with employment matters that have reached the point of dispute between employee and employer, and they can't be resolved. And as great as that is for our business, if employees and employers get into fights, ideally employers have the right policies and procedures and systems in place, as I'd mentioned earlier, in order to mitigate those risks. And so, Vered, maybe you could tell us a little bit more about VIMY and the services that you guys provide and how it is that you help businesses do what I just mentioned.
Yeah, I'm grateful when we have organizations that reach out to us early in their growth. So when they're at sort of that 5-employee mark and they say, okay, well, we know we need some level of support. We don't even have policies, or we don't have a proper contract. We downloaded something off the internet and that's not going to work anymore. I know, eeks. So, those are my favorite clients, because they know that they've had the experience maybe working as an employee elsewhere and know that that's a huge risk as you continue to grow and you sort of lose that culture and the full control of all the things that happen in your organization. So you have to have some level of like constraints and boundaries, policies in place, a proper contract to support your business, to mitigate risk. Unfortunately, a lot of the times they've waited and they have their first wrongful termination lawsuit, and they've had to pay out maybe $40,000 that they didn't have as a very small business. And then we get called to say, okay, well, we've learned our lesson now, and we want to do things properly. So that's where we come in, as we are really supporting these organizations and mitigating risk, reaching out to HMC, to Meagan, and saying, hey, we have some level of understanding of what this employee contract should look like, but we need your legal advice to get this into a solid position, and putting together some at least basic policies. I don't like putting in too many policies, especially for small businesses. You still have to have that level of agility, but to mitigate risk, like in terms of having a code of conduct, a leave policy in place, some level of understanding of how to manage vacation, workplace violence and harassment prevention, some of those core policies in place so that it protects the employer and educates everyone in the organization as to what that level of behavior and conduct is appropriate.
Okay. And now you guys are external. I mean, you provide services to these businesses. So how is this different than having sort of an internal HR person? Are there, benefits, drawbacks either way?
Well, I think the benefit that we bring is our experience. We've done this so many times over. Our experience is deep rooted in terms of supporting small businesses and their unique issues, not, trying to keep things simple and creating a sustainable system for them, because we know it's going to live and breathe beyond us, hopefully, as they continue to grow and they need to hire an HR manager. So, yeah, and they don't need full-time support when they're a small business. And so there's a lot of cost savings that we bring, because we can do the strategic part of really setting them up for success, as well as being an integrated business partner in their organization to get to know their business, help their leadership, build their capabilities, as well as mitigate that risk.
And I just want to kind of clarify, like in terms of when we're talking about small businesses, like what are we talking about in terms of like the number of personnel and things like that?
Yeah, I know there's different classifications out there, and some people associate it with how much revenue an organization is making. For me, I would say anything under 150 headcount would be a small business.
Oh my, okay. See, I have a complete mistaken view of what a small business is. So, but again, yeah, I haven't been on the other side of these things. So, now, Meagan, do you have any additional comments about sort of like the interaction of, yourself with VIMY and the types of services that you've been involved in?
Absolutely. So I think Vered made sort of a really good point. I don't know if she intended to, but basically the best case scenario in terms of involvement of a lawyer from an employment law perspective is you really only want to involve me if things have already gone wrong. So if somebody's already sued you, if you're already in a situation where there's sort of an immediate crisis that needs to be dealt with through litigation, I'm your girl. I'm happy to help you out. But what doesn't make sense is to hire me necessarily kind of on that front end to draft all of your policies. Someone like Vered, company like VIMY HR, they're very well suited to do that sort of thing in an efficient way. And then to have me or someone like me look over it, make sure it's still compliant with sort of the things it needs to be compliant with. The things that you're often worried about when you're looking at policies like this is, are we meeting our obligations from an occupational health and safety perspective, for example? Are we onside human rights legislation? Are we consistent with the Employment Standards Code? Those are the sort of things that I can look at a policy someone, like Vered has already drafted and make sure, yes, absolutely, that looks good. I can tell you that I'm satisfied with that, and that's going to protect you. And then again, if something goes awry later and you need to hire me and you've had those good policies in place already, it makes my job a lot easier, which means that I'm a lot cheaper for the client if I'm dealing with well-established policies, if I'm dealing with contracts that were drafted in accordance with sort of the most up-to-date law. It means that what you end up hiring a lawyer to do is say, wow, you did such a great job. Your defense is going to be really straightforward, as opposed to hiring me when you don't have policies, nothing has gone right, and I'm trying to look back in time at something that you, like Vered said, probably downloaded off the internet and say, okay, well, what was the intention of the parties in entering into that employment agreement? What was it that you meant to do? How was it that you meant that agreement to terminate ultimately at the end of the day? So basically, if you rely on Vered at the beginning, if you need me kind of later, it's going to end up being a lot more efficient. It'll end up being easier, and your legal fees will be less. And we all know that as much as I love working with small businesses, they don't love paying me. They would rather be able to put that money back into their business or, profit.
Okay. And actually something just, sort of popped into my head. I mean, not even just the legal landscape, like the world we're living in is changing a lot in terms of, workplace appropriateness and all this type of stuff. And I can put this to either of you, maybe starting with you, Vered, like are companies needing a lot of help kind of navigating, updating maybe policies or, making sure that they're kind of on side with, what is expected in workplaces these days?
Oh, absolutely. I think when I first started my career, I saw handbooks being reviewed and revised maybe once every 7 years. And now it's happening every 2 years, because the reality is that the workplace is changing and the expectations on employers are changing very rapidly. higher level expectation of workplace conduct, and creating safe environments for our employees. So, and then, in terms of the rapid shift in technology, so we're seeing absolutely there's a requirement to take a look at those policies continually and update them to our current reality.
And is that, so I'm picturing, and maybe this was just from the show The Office, this might not have actually been how workplaces were a long time ago, but I'm picturing some of those old like VHS like workplace appropriateness videos and stuff like that. Do you guys also do like educational stuff in terms of, so there's the policy drafting, but then also sort of just educating employers and employees about what's appropriate in a workplace?
Yeah, absolutely. It's not enough to just roll out a policy and say, here you go. There has to be some level of training. And so when we do roll that out to a newer organization and these startups or scale ups that we're working with, there's always a component of training where we are training the managers or leaders on what that looks like, what that means, and how do you support the enforcement of these policies, but then also training the employees themselves on expectations of abiding by the policies.
Okay. And yeah, Meagan, maybe like, are there issues that you're noticing are coming up more frequently? I guess, again, you don't have that many gray hairs, so you might not have that long ago to compare it to, but what are some of the more common things that you're finding employers are having issues with?
Sure. Yeah, no, I think on both fronts, there's sort of two things that I would highlight. I think Vered's right. One of the big changes is sort of technology, and how that impacts sort of your policies, procedures, and also just generally how workplaces operate. And I'd say that this is really like a COVID era kind of change more than anything else. Yes, things have gradually changed kind of as technology has, but COVID really kicked it into high gear, particularly with issues around remote work. That can get super complicated, both in terms of how you pay people, but also in terms of how you monitor their work and sort of their success and what they're doing, and setting up sort of appropriate ways to measure people's success and their level of sort of involvement in a company. That can be really complicated. Sort of really on the other end of things, figuring out what jurisdiction the person works in. If they're a completely remote worker, that can be quite a headache in some scenarios, and it can apply differently in different contexts. So they can be, an Alberta worker for a certain aspect of things, but they might, ultimately be considered a worker of a different province for the purposes of tax. So this can be complicated, and it's sort of a shifting landscape still. So that's something that comes up more and more frequently, I would say. And then the other thing for sure, I've absolutely watched more and more human rights complaints come in. I would say it's definitely a big change from a litigation perspective. So you're seeing more and more of that. I think part of that is probably just that people now are more aware of their rights. So they're more likely to assert them. And I think that's good from a societal perspective. But on the other hand, it does mean at the end of the day, people do bring complaints that are not always necessarily legitimate. And these complaints do not cost money to file. They are online fillable forms. There is a very low barrier of entry. And it does create a situation where an employer needs to absolutely respond to that. And that can be costly and time consuming. And the thing too is because of the way, and unfortunately, these things tend to work out from a timing perspective. You're often responding to a human rights complaint 2 or 3 years after kind of the subject behavior. So employers will sometimes not have any notes about what happened, or they'll not have the same staff. The HR person will have changed. If they don't have appropriate systems in place in terms of keeping records, in terms of managing performance for employees, it's really tough for them to respond to these complaints. So there's sort of a couple different issues there. But I'd say those are probably kind of the two primary things that I've noticed is sort of issues around remote work, both from a policy perspective and from a just sort of pure legal issues perspective. And then just all the complications that come with a higher number of human rights complaints being made, at least as far as I can tell. I don't know if you agree, Vered, if you're seeing more of that.
Yeah, absolutely. We're hearing a lot more in terms of just complaints in general from employees. And I agree with you. I think the level of awareness of the workforce now around their rights has escalated, and I think there's what has changed too is that they're going straight to making that complaint rather than trying to seek clarity, trying to have conversations. So our role is really actually focused on creating better leadership, because that's where we can intercept that complaint and really having a relationship-driven workforce that is having more communication with their staff, that can create those open lines of communication to have conversations and hopefully mitigate the risk of those employee concerns going to a human rights complaint that might not be valid.
Well, and that's the thing. I mean, yeah, validity aside and all these things, right? And Meagan kind of talked on this, obviously, in all aspects, access to justice is incredibly important. And it's obviously going to lead to a lot of interesting and, yeah, perhaps not so legitimate lawsuits, complaints, and all kinds of things coming in. But it's, like you say, it's more so about employers being aware of those things potentially coming up. And making them better understand all the things that they can do to, again, we're saying this over and over again, but mitigate those risks and minimize the chance of ending up in that position. And if they do end up in that position, have the tools to respond and deal with it. Is that fair?
Oh, absolutely. Yeah, it's really about creating leaders who understand the landscape and what is happening and how they can mitigate those risks, how they can build relationships, how can they communicate better, and how to manage their teams better.
And so maybe that helps us segue sort of into getting a little bit more particular about this then. So how can employers sort of best prepare themselves to manage different types of terminations? How can they be best situated to deal with that?
Well, thinking about it sooner than later would be one aspect. So, not waiting until you have that first wrongful termination lawsuit and you've actually had some support in looking at your employment contracts, your severance packages, getting support from HR as well as legal in particular. We are not experts in knowing what common law is at this point, and again, it's changing rapidly. So, getting that advice and for HR and legal to collaborate on those types of situations is really important. But really having, your contracts set up properly is really important because you can mitigate a lot of risk there too. You can have clauses in there in terms of what is the severance cap potentially, and maybe Meagan can talk to that a little bit more because I know that's changed several times over. And then secondly, yeah, maybe even thinking in advance, and this is something that we just did with one of our startups, is putting together a termination package and a script. Because a lot of the times the leaders don't know how to have those conversations or what they can and cannot say and get themselves into hot water. Not doing them alone, getting support in advance from HR and legal before you make that decision, before you have the conversation, before you do the exit, is really important, and potentially getting training as well on managing those situations.
Meagan, your thoughts?
Sure. I'd say you're absolutely right, Vered. It's certainly important to have appropriately sort of organized contracts, especially when you're talking about termination provisions. The law on this changes a lot. And basic idea is that if you're going to deprive somebody of their common law rights to common law severance in Alberta, it needs to be done in a very clear and explicit way in the contract that they enter into, ideally at the time that they are hired. So that can be a complicated thing because the law can be one thing when the person's hired and it can be a different thing when they're terminated. That happens pretty frequently. And you can see sort of cultural shifts around what is an appropriate termination provision in different provinces. So it's much harder to deprive somebody of their common law rights in Ontario, for example, than it might be in Alberta. And I would say, in addition to that, and in addition to having employers sort of trained on how to handle terminations, there's also, at least when things come to me, one of the primary issues a lot of the time is that people will want to terminate employees sometimes on the basis of conduct, but the conduct won't have been documented in any way, and it won't have been subject to some sort of a progressive discipline policy or any sort of discipline policy. So what will end up happening is someone will come to me with myriad complaints about the employee over like 5 years that they haven't documented, that they haven't discussed with that employee, that they, are just so tired of, but they haven't given the person an opportunity to address it all. And the difficulty there is they'll feel like they have to terminate the person because a relationship will be so poor by that point that there's just no realistic chance of an ongoing viable employment relationship, but they won't have documented any of these conduct issues. So it puts them in a really tough spot. Are they going to terminate with cause at that point? It's really risky. It's really risky to do that. So what will end up happening is people will end up terminating people without cause when they may have had cause because they don't have the evidence. Basically, they don't have the ability to back that up, and that ends up being a much more costly endeavor. Whereas if you have sort of an appropriate progressive discipline policy in place and that policy is followed, and it's followed all the time with all of your employees, it means that if you do end up needing to terminate somebody, you'll be able to do that more easily. And in my view, you're also less likely to have to terminate people with cause, because if people are given an opportunity to correct their behavior, chances are they will. Now, that's not universally true, but I do think giving people an opportunity to correct that behavior is the smart thing to do. And like I said, sort of in my intro, for most people, their employment relationships are really important to them. And they care about their job and they take pride in their job, and they, no one wants to get fired. Right. So if given an opportunity to avoid that, most people will. And the reality too is if somebody gets disciplined a couple times for something and they really just don't agree with it, and there's sort of a philosophical difference here between how that employee wants to operate and how the employer believes that they should operate, that person may also just leave on their own and decide, well, this isn't the right place for me, so maybe I'm not going to stay here. So you might avoid that issue altogether if you're sort of clear about what your expectations are and you communicate those expectations to people clearly. You'll eliminate a lot of these issues. And if you do end up in a position where you need to terminate the person with cause, you're in a much better legal place to do so.
That actually, so although I don't really practice in employment law, I actually did run a small claims court trial over a wrongful dismissal that sort of involved, sexual harassment, assault type stuff. And one of the big issues that kind of came up at the trial was that this individual was sort of arguing that he should have been subject to the progressive discipline, because they did have the policies, but there just seemed to be some confusion over whether something like that's deemed a sexual assault would kind of skip over all of that and just go straight to cause. But I guess I kind of have a question about how specific would you get in either policies or other materials that are an education that is provided to the employees about those things, so that they understand the types of scenarios where they might be dismissed for cause? Like, does that
Sure.
make sense?
Yeah, so I would say that generally speaking, in most employment agreements that I'm involved in drafting or reviewing, there will be language which says at any point, your termination, you can be terminated with cause for something that constitutes cause legally, and you will be provided with no notice. So I think the kind of primary thing that you're getting at here is sort of what we sometimes call sort of like a summary dismissal versus a dismissal kind of on the basis of a progressive discipline policy. So something that constitutes an assault, you are going to be able to terminate that person immediately. Something that constitutes a serious enough offense that the working relationship is such that you just can't continue to work with them. Again, I would suggest that you get legal advice on this point, but ordinarily that's something you can just terminate the person kind of then and there. It's not always obvious what that will be, but an assault is certainly an obvious example. Destruction of property can sometimes be an obvious example. Theft is an obvious example, though in all of these instances, you should still consider whether or not an investigation makes sense. Otherwise, with a progressive discipline policy, it just needs to be clear, right? And oftentimes the progressive discipline policy might say something like, you'll get a verbal warning, you'll get a written warning, you'll get a second written warning, and then you'll be terminated. And usually that stuff relates more to your failure to perform. So your failure to meet sort of the obligations of your job, failure to do the things that you're meant to do, or your failure to meet certain policies and procedures, which are ideally laid out in an employee handbook that someone like Vered drafted or reviewed. So, progressive discipline might be something like people who are chronically late, for example, with no good excuse for being chronically late. That could ultimately lead in a dismissal if you've been warned. If it's happening over and over again, that is the sort of thing that might result in it. Again, also performance management. If you repeatedly fail to meet targets, you've been warned about this, you've been given opportunities to correct this, you continuously fail to do this, you could eventually be terminated for something like that under a progressive discipline policy.
Yeah, that, obviously to us lawyers and us in the industry, we can kind of like divide these things for whatever reason. The employee, his lawyer, and even the trial judge seem to misunderstand that a sexual assault should be grounds for cause. But in any event, we won on appeal. It's all good. Vered, do you have any additional thoughts on that?
Yeah, that all sounds very reasonable and aligned with my experience. I would say we do work with quite a few employers who want sort of the black and white answer for how do I terminate with cause. And it's very difficult to do that, first of all. And so, they are always looking for policies to make things easier, but at the same time, there's so many scenarios that can be at play in a workplace, in terms of performance issues, in terms of, just workplace behaviors. And so, I always actually advise that we don't put so much in writing, because then we can make some decisions and get legal advice and get a plan in place. We've come into situations quite a few times where it's muddied waters, and so we have someone who has been continually in and out of the workplace on leave, but they're also accompanying that with many performance issues. And so how do you navigate those waters? You've got some performance issues, you've been dealing with those, and then someone starts to have some disability issues, or they're on leave. And so, how do you protect an employer with those scenarios through policy? It's really challenging to have a cut and dry solution. And so we often lean on our employment lawyers like HMC and Meagan to say, okay, this is the scenario. How do we put a plan in place to mitigate employer risk, also do the right thing for the employee? And so a policy doesn't always protect you.
And so you started touching on the overlap with, like, if somebody's in the midst of a disability claim or something like that. So what are some of the issues you've seen or have encountered? What maybe gave rise to those issues? And then what sort of solutions were you able to offer?
I've seen this happen a lot where someone's put on a performance improvement plan, they're not meeting their targets, and it rightly causes a lot of stress for them, and so they end up going on a medical leave for stress, for some mental health challenges that they're experiencing, and so then it becomes a challenge of how do you navigate that scenario. If you've documented it before and you've had those conversations, so maybe a little bit easier. But there are many scenarios where we need the expertise, and we need some guidance from our employment lawyers as HR professionals, just to make sure that we're doing the right thing from a human rights standpoint, and legally.
Megan, are you able to comment a little bit more about the human rights side of things and the legal side?
Yeah, absolutely. I think that is a primary risk in that scenario is going to be a human rights complaint, because employers can't discipline somebody for having a disability, and medical issue is a disability pursuant to the definitions under human rights legislation. So it's difficult, because if somebody's having performance issues because of a medical issue, you can't discipline them for that, right? But the scenarios Vered's talking about is a little bit more interesting, because you're talking about someone who maybe didn't have a medical issue or a disability impacting their performance. They had performance issues, and the way that they were managed ultimately caused them to go on a stress leave. So you're dealing with kind of the converse. So I think, again, this is a really fact-specific situation. It really depends. Like, you need to look at the full employment history of that person. You need to look at what's going on. And I think the thing to keep in mind, too, is an employer, if you notice that somebody's having performance issues, it's important to talk to them about it. In the scenario Vered gave, there's somebody on a performance improvement plan, which is great. Not all employers do that, though, and they don't always have it. Instead, what will happen is they'll just notice that somebody's performance is bad. They won't say to them, hey, your performance isn't looking good. Let's talk about ways to improve it. Let's come up with a plan. Let's meet in a couple weeks and see how that's going. They'll just say your performance is bad. I've noted that it's bad in your file, and, smarten up, kind of thing. And that's not necessarily onside your obligations as an employer. If someone seems like they're really struggling, and they might not be doing well from a health perspective, from a mental health perspective, you should be saying, hey, what's going on? Is there something I can do as an employer to support you? Are you aware of, potentially access to benefits? Are you aware of the fact that, if you need to take some time off from a medical perspective, that you're entitled to do so? Have you spoken to your family doctor? These are things that good employers do in order to, again, be good people, be good employers, but also to mitigate that risk, right? You want to do everything you can to accommodate people. Your obligation as an employer is to accommodate someone to the point of undue hardship. And if you have a long working relationship with an employee and they're not sort of behaving in the way that they ordinarily do, you should be asking what's going on. Why are you behaving this way? You need to give them an opportunity to talk to you about that, to try to address that.
We're kind of getting a little low on time here, but Vered, do you have any other thoughts on that after what Megan had to say?
No, that's great. I think I just want to hire her onto my team now.
I know, she really sounds like she knows what she's talking about. Yeah.
It's like she's navigated these waters several times over.
Oh, Vered, I think you have too. And it's great for people like me to have a relationship with someone like you, with someone like Vered, because it's good for us to be able to bounce ideas off of each other too. That's sort of a secondary way, I think, in which lawyers and people who work more directly in HR can collaborate in a manner that's effective for clients is Vered will have run into stuff that I haven't run into potentially because she deals with a greater volume of sort of employment issues than I do. And then I may have dealt with something a little bit more on the technical side. So we can collaborate together and come up with good creative solutions for clients that are cost effective and efficient is the other thing. It's efficient when we work together.
And I think the thing that I would add is, like, really, if we can tag team on coaching our leaders, because a lot of times they're scared. They don't know that they can have the conversation around, hey, we're noticing these performance issues and these are your options if you are experiencing mental health issues. Like, they don't even know that that is something that they can open the door of the conversation on. So having someone like an employment lawyer who's been through these scenarios, who knows where those boundaries are, speak to you and coach you, rather than just, providing you a template or advice. Like, it's beyond that, and actually having a relationship with a great employment lawyer is really important for leaders, and especially small businesses that have never encountered these scenarios before. Everything is brand new for them.
Yeah, well, I was going to say, and Megan, you took the words right out of my mouth. I was going to say, it sounds very, collaborative between you two. That's how this kind of conversation has gone. You each have, different expertise and perspectives on things. And I think, the more you can kind of, draw on other people's expertise to sort of help navigate this process, the better. So that all makes sense. So I guess, like I said, we're sort of running out of time, but I'll start with you, Megan. Any closing thoughts sort of to leave, whether it's employers or employees, messages to leave, or even employment lawyers or other HR personnel, messages to leave them with from this podcast?
Sure. I mean, I think, primarily as a message to employers, don't be afraid to reach out, right? Don't be afraid to reach out to an HR professional early on. We talked a lot about risk mitigation today, and I think the best way to mitigate risk is to be prepared. And the way that you do that is by talking to people early, by ensuring that you have things appropriately set up. And then also, look, if you made a mistake and you didn't have things appropriately set up, call me. Call me before you terminate the person, ideally. That's kind of the better time for me to be involved as opposed to later. But basically, don't be afraid to hire a professional to help you with these issues. At the end of the day, I do think it ends up being more cost effective, both in the short term and in the long term.
And Vered, what about yourself? Any closing thoughts?
Yeah, I would say for employers to invest early in some of those foundational elements, like a solid employment contract and your core policies, and getting set up with an employment lawyer that you have a good relationship with or can build a good relationship with.
Okay, well, I think both of you have made a very good case for the services that you're able to provide today. And I'm so glad that you're both here to chat with me about this. And I'll just say thanks one more time, and thanks to our listeners. And we'll catch everyone on the next episode.
Thanks, Kristen.
You've been tuning into the Lawyer Up with HMC podcast with your host, Kristen Hagg. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, hmclawyers.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.